Back, everyone. Thank you for rejoining us following lunch. And we, as I mentioned upstairs, have a terrific panel on comparative perspectives on implementation. Given the weather, we have a few substitutions. Andrea Carmen from the International Indian Treaty Council could not join us and sends regrets. My colleague from MRIP, Alexei Isayev, will moderate in her place. Thank you very much for doing that at the last moment. He may also share perspectives from implementation through MRIP as well as his own home country of Russia. I won't introduce everybody because that's Alexei's job, but we also have another substitution. Kenny Yoshida will be speaking. Chief Willie Littlechild, Grand Chief Willie Littlechild was unable to join us from Canada for the same reason. And Kenny is a wonderful scholar who will speak on the Ainu people in Japan. With that, I will turn it over to Alexei, except to say that after this panel, there will be a 15-minute break if there's time, and then today's concluding panel will again be moderated by Heather Whiteman-Runson, and then we'll have a few reflective remarks at the very end. So thank you. Alexei.
Thank you, Kristen. Good afternoon. Again, my name is Alexei Isayev. I'm a member of the Expert Mechanism on the Rights of Indigenous Peoples, representing Eastern Europe, Russian Federation, and Central Asia. And also domestically, I'm chairing an NGO, which is called Center for Support of Indigenous Peoples and Civic Diplomacy, Young Karelia. And we are dealing with indigenous peoples' cultural, linguistic rights mostly. And this month, I also reside here in Boulder, Colorado Law School as a visiting scholar. So it's a pleasure for me to moderate this panel. And just to introduce the topic, the theme for this panel is comparative perspectives on implementation of the UN Declaration on the Rights of Indigenous Peoples. Just recently, 2 years ago, we celebrated and marked the first anniversary of the UN Declaration. And I think Colorado Law School was one of the hosts of events to mark this anniversary. It was a good opportunity to everybody to reflect on achievements, backtracking advanced practices and challenges when it comes to the implementation of this document. I remember 2 years ago when in the expert mechanism we discussed our report on the implementation of the declaration. So we encountered some difficulties in providing regional examples in a way that we get a comprehensive and balanced document because the situation in various regions is very different. And there are regions and countries where the declaration is being used in policy making, in judicial practice, etc. But on the other side, there are regions where the declaration is still a document existing somewhere far in the United Nations, where governments fully commit to it, but domestically do not pay much attention to the declaration. The country where I come from, the Russian Federation, abstained in 2007 when the UN declaration was discussed and voted for in the General Assembly. And major reason why Russia didn't vote in favor of this document, according to Russian officials themselves, is the fact that the Russian legislation and the constitution provide even better standards for the rights of indigenous peoples than the Declaration on the Rights of Indigenous Peoples sets. Of course, it's something which indigenous peoples in Russia do not agree with, and I just recently attended a meeting in the Russian parliament where a number of indigenous rights issues were discussed, and I saw the background document for that discussion, which said that Russia does not accept and Russia does not recognize the UN Declaration on the Rights of Indigenous Peoples. And I had to take the microphone and actually remind that Russia was among 193 member states who gathered together in 2014 in the General Assembly for the World Conference on Indigenous Peoples and agreed with the outcome document of the World Conference, which says that all states commit to the achievement of the ends of the declaration. So that all the states reaffirmed actually their commitment to the declaration, and that's how Russia and all other countries accept and acknowledge the declaration as a minimum standard. Therefore, it has become quite hard for states to just ignore the UN declaration domestically and internationally, and that's how the practice of the implementation of this document continues to develop. So on this panel, our aim is to share lessons and practices that exist in different countries and regions, including legislative, judicial, administrative, including activism, social practices, and so on. And we have on this panel very distinguished and outspoken speakers, which is my honor to introduce. First is Christina Koch. Christina is a Quechua Mayan community leader in southern Belize, and she has served as co-spokesperson for the Maya Leadership Alliance and is a founder and executive director of the advocacy organization. In 2015, she was awarded, among others, the Equator Prize for the efforts in protecting indigenous people's rights. Next speaker is Kunihiko Yoshida, Professor Kunihiko Yoshida. He earned a PhD in civil law from Tokyo University in Japan, and he has served as a visiting professor in a number of universities, and currently he's a visiting professor here in the University of Colorado Law School. Professor Yoshida currently researches repatriation, environmental injustice, and traditional indigenous knowledge in support of pressing agenda of the Ainu people in Japan. And he also writes articles on civil law, contracts, properties, health law, and family law, and so on. Our next speaker is Tracy Wah from New Zealand, and she has traveled all the way from New Zealand and probably is the most distant our participant here. Unfortunately, we've learned about a terrorist act which just happened in Christchurch in New Zealand, so I would like to express condolences on behalf of this conference for New Zealand people. And Tracy is a lecturer at the University of Auckland, where she teaches treaty issues, indigenous people's rights, and international law, and legal research and writing. She also works with Maori communities to strengthen and foster the rights and legal systems, and regularly engages in advocacy on the UN Declaration on the Rights of Indigenous Peoples. And last but not least, I would like to introduce my chair in the expert mechanism, Erika Yamada. Dr. Erika Yamada is the representative for Latin America and the Caribbean in the UN expert mechanism on the rights of indigenous peoples. And she is very outspoken in Brazil as the national rapporteur for the rights of indigenous peoples. And she has worked also with the government of Brazil when it comes to indigenous peoples, and she does a lot of local work to strengthen communities and empower communities to use international standards. So I hope that Erika would also elaborate on the MRIP mandate, which is very important now for the implementation of the declaration. So having said that, I would like to give the floor to our panelists and encourage them to use 12 minutes. And then if we have time, we can have a little discussion. So Christina, please.
Good afternoon to all of you here, leaders in your respective rights, colleagues, friends of the Maya people. Certainly I bring a warm welcome from my people from southern Belize. Just keeping with the theme for this session, comparative perspectives on implementation, I'd like to focus my talk on the last 3 decades of testing Maya people's resilience, and perhaps more pointedly talk about the recent developments in terms of implementation and in terms of using the declaration as a very important tool to see and bring forth steps in the implementation. To begin, the modern Maya land rights struggle is a 3 decades long process of direct negotiations and strategic litigation against the government of Belize by the Maya people. It culminated in 2015 when a consent order and a judgment was issued by the Caribbean Court of Justice. This is the highest domestic court of Belize. In this decision, it affirmed rights of the Maya people to our ancestral lands, and it obligated the state to protect these property rights equal in protection of property rights as guaranteed under the Constitution of Belize. The lower courts, whose decision was affirmed by the Caribbean Court of Justice, made it clear that aside from obligations under the Constitution of Belize, the government also had obligations that arose from international law. Whether that be from prior decisions by the Inter-American Commission on Human Rights, international instruments ratified by Belize, or under developing customs expressed through such aspirational documents as the United Nations Declaration on the Rights of Indigenous Peoples. 3 years after this historic decision, and as we are here to discuss implementation in particular, I wish to speak about what has happened since the 2015 decision. After conceding to the Maya land rights, after much struggle, the government of Belize's immediate reaction is that it is for the government, it is for the state to implement the court orders, and that the Maya people have no business in implementation, and that it is the government that will protect the interests of every Maya person. The next 3 years after the decision were marred with differing interpretation of the consent order. After these 3 long decades, the same government who violated our rights time and time again now turned protector of the Maya people, but completely disregarding the traditional processes of consultation and decision-making of the Maya people themselves. A government that was fixed on the position that it was for them to implement the decision. So how did the Maya people respond? Back in October, I was here representing the Maya people during a session of the hearings of the Inter-American Commission on Human Rights. And even at that time of that session, we were reporting to the Inter-American Commission on our government's unwillingness to even consider meaningful negotiations with the Maya people, and the sheer lack of progress in the prior 3 years since the 2015 decision. However, we have been pleased to see that in the last 3 months, there has been more progress with the government towards implementation. One, the government has signed an agreement with the Maya people to set the early stages of implementation. And as we all know in this room, governments sign many agreements. So while that is to be celebrated, it is also to be something to be vigilant about. As a part of that, the government has agreed to allow Maya communities to auto-delimit the outer limits or the outer boundaries of our traditional territories. In fact, Colorado University's own Joe Bryant is helping immensely to guide the mapping process along with the Maya people. This was a very difficult part of getting the government to accept, because governments want to come and tell you where your territories are. And it is only the Maya people, only the people who live and feel a part of that land that can determine where those boundaries are. They have developed a joint Maya land tenure policy with our representatives, Hopefully one day this can be developed into meaningful legislation. And finally, they have appointed Professor Dinah Shelton from George Washington Law as a dispute resolution authority to help to limit new and ongoing violations on our lands and to our people. While the focus here is on progress in terms of implementation, and while I celebrate the progress that we have made, and what I have mentioned to you is definitely good evidence of such progress, I just want to emphasize that it is still very early. While we are optimistic about these agreements of progress in the past, while we are optimistic about these steps that the government have taken, we remain vigilant because we recognize that this same government who has violated us for the last 3 decades have also made promises in the past, agreements in the past, without following through with those agreements. One example that I can point to, and for those of you who have followed the Maya land rights litigation, in 2000, the government signed a 10 points of agreement with us, went through the same process of outlining the steps for implementation, none of which it actually fulfilled. The Maya people have been consistent in grounding our approach to ongoing negotiations over the implementation of Maya land rights in the UN Declaration. The Declaration is a globally accepted minimum standard for correcting the historical wrongs suffered by Indigenous people. The Maya people, in applying and leaning on the Declaration as a guiding framework, has pushed the government of Belize to come to terms with the need to engage in a mutual and respectful partnership leading to the joint drafting of the Maya land tenure policy, which I would like to read a section of for you just to give you an idea of how far we've come with this government. And I quote, "The government is committed to moving forward with open and transparent dialogue with the Maya people and to jointly develop and implement structured, collaborative actions focused on guaranteeing and ensuring the exercise and enjoyment of their rights as Indigenous peoples and as citizens. Promptly resolving these issues in a matter of respect for fundamental constitutional rights and the rule of law, firmly in the public interest and a measure of good governance, sustainable development, and democracy." The Maya people did not take up litigation because they believe that the law will fix their historical sufferings. Litigation was understood by my people to be a strategy to buy time because it accepted that colonial laws must reconcile with the original laws of the Indigenous people and their lands. While the Maya people were focused and ultimately secured a favorable decision in the court, the leaders were already looking into the future. Some key areas of focus included revitalizing Maya system of traditional governance, applying the Maya language in the functions of our struggle and our organization, revitalizing efforts to care for the natural resources, especially forest products, joining thoughts on building a Maya economy. These priorities, put simply, say that we must make our own decisions using our own ways. And I think that that is what we mean when we say self-determination. We must all understand fully that what we decide in our own language, we must be responsible for our own lands and resources. We must create opportunities for our people based on our own priorities. It is the experience of the Maya people that the state will act to weaken our abilities. It has attempted to coerce and assimilate the Maya traditional system of governance. It has demanded that English be the language of communication. The Maya people remind the state of the global standards under the Declaration, and in this case specifically, Articles 4, 11, 18, 19, and 23. The consistent application of the Declaration in the day-to-day reality of the Maya people's negotiated space within state has resulted in the Maya people pushing for mutual partnership and respect. This is the spirit that is now driving the development of the agreement and the auto-delimitation process and the Maya land tenure policy, and hopefully soon the development of Maya land rights legislation. In closing, I want to emphasize that international law, and the Declaration in particular, have a pivotal part of the progress that the Maya people have so far enjoyed. But perhaps what is most important for Indigenous people is for they themselves to adopt the meaning of the Declaration in their own context, in their own realities, and in their own language, so that when states rely on such declarations, it would be meaningful to the people that it is being applied for. Second, I want to emphasize that we have seen that nothing happens overnight, and that perhaps the greatest threat has been Indigenous people's frustration for years and years of litigation. Yet even when positive court decisions are given, the implementation process is painstakingly slow. One of the reasons we have been able to maintain our community's resilience is because the Friends of the Maya people have given endless time, energy, research, and support of our efforts. And finally, I want to echo what one of my colleagues here said this morning, the importance of coalition building. But perhaps thinking of coalition in the sense of building our support around examples where implementation has been successful. And in this case, I encourage you to continue to follow the Maya land rights case and to give us your support in whatever way possible so that this global struggle to see the implementation succeed is upon all of us. Thank you very much.
Thank you very much, Christina. And now I'd like to give the floor to Professor Yoshida, please.
It's on. Hi, thank you for this occasion. I'm Ken Yoshida from Hokkaido University. But since last August, I've been visiting here at CU Boulder. There are two accidents. First, I rarely catch cold, but I have been sick in bed for the last couple of days, and sorry about my voice. And second, I've invited two of my friends from Hokkaido, but their original flight from Tokyo to Denver was canceled yesterday, and they made up their mind to rent a car, and they were carried to San Francisco Airport instead, and by renting a car, they are heading to us to attend this important meeting, and hopefully they will show up soon. And as moderator introduced me, I'm a jack of all trades, but as one of my research projects, I've been working on reparations in the East Asian context, such as comfort women, slave labor, or Chongqing bombing, Nanjing massacre, things like that. And the reparations with regard to Ainu people is the indigenous people in Japan, is a good example. And listening to Jim's lecture, I really thought that Japan is a completely different world with regard to UNDRIP. So I prepared more than 50 slides for this talk, but giving up my talk on them, I just made 5 slides of synopsis before the beginning of my lecture. So I just talked about those synopses. Okay. Synopsis number 1. The Japanese local and central government virtually rejects the UNDRIP, even though Japan signed it in 2007. It's amazing. It still rejects the reparations approach with the aid of Hokkaido University professors. I'm also a Hokkaido University professor, but we are divided, as you may gather. And it still hides the past injustice towards Ainu people. They suffer tragedies successfully if you study their history in the past. Similar to other indigenous peoples across the world, the Ainu land was confiscated shortly after the Meiji Restoration. Meiji Restoration starts from 1868. So last year is the 150th memorial year. So not long time ago. And they were conquered shortly after the Meiji Restoration. Their original occupation of hunting and fishing was prohibited, and their mother tongue was also prohibited. As the flip side of the coin of the monolithic image of Japanese society, the racial minority in Japan, such as Ainu people or ethnic Korean, are still oppressed, marginalized, and discriminated against. They are still facing serious hate speech. This is the Ainu pictures, for example. And second, if you look at the bottom, so already in the 1870s, shortly after the Meiji Restoration, as I mentioned, shortly after 1868, in the 1870s, Ainu lands were considered the state land by the Terra Nullius doctrine or discovery doctrine without making any treaties. So mainlanders, spearheaded by government officials, invaded Hokkaido. In those days, the Ainu people are spreading. They also live in Kurai Island or Sakhalin Island. And the campus of Hokkaido University used to be an Ainu village. I'll show you a picture later. And the basic Ainu land statute at the beginning is called the Hokkaido Formal Native Act of 1899, based on the General Allotment Act here in the United States of 1877. But so the small tract of land, 5 hectares, that equals 12.38 acres of land was allotted to each Ainu family for promoting agriculture under the stringent condition of cultivation within 15 years. But most of Ainu people were unsuccessful. So they lost everything. They were displaced from their original area, the coastal area, because of their original occupation of fishing and hunting. And then they were displaced to mountainous, barren lands. So in case of Dawes Act, the 160 acres, 80 acres, 40 acres for those people, so there's a big difference. And in Hokkaido, for mainlanders, 1 million hectares of lands were allotted, almost everybody. This is quite a good example of unequal treatment for Ainu people. Unlike the Dawes Act, that was abolished in the 1930s, the Ainu Land Act was valid until recently. the 1997. So this is a picture of allotted land, some of them near cliff, or some of them are very hilly in the Kushiro city, the easternmost city of Hokkaido. And this is the picture of my campus. The Hokkaido University is the most beautiful and most spacious university in Japan, but it used to be Ainu land. And there's a beautiful small river flowing in the campus, but that's exactly where Ainu people used to live. And from the Ainu tombs in the campus, the German travelers stole with the aid of American botanists, sold to Germany. And quite recently, the international repatriation occurred in the Japanese embassy in Berlin. Synopsis number 3. The agenda of the recent Ainu legislation is the construction of Ainu Park in Shiraoi by 2020. However, the grave injustice is hidden in this project. More than 1,000 of ancestral Ainu remains and cultural artifacts were stolen by professors of Hokkaido University and others from almost all Ainu tombs across Hokkaido. By this Ainu Park project, all ancestral remains will be consolidated there to forget about a past injustice. That is quite opposed to the repatriation advocated under Article 12. The commodification of Ainu sacred, genuine cultures will also be serious. Subsidies for the promotion of Ainu cultures are given to local governments, not Ainu people. The National Ainu Museum, newly built by splurging huge budget, will be quite different than the Holocaust Museum or the Native American Museum in DC because Japan still denies reparations in its broad term. And so without any exhibits of human rights infringement of Ainu people, the exhibit there is quite different. So this is the plan of Ainu, what is called Ainu Symbolic Space in Shiraoi. And this is a national museum, but the exhibit might be quite different. And this is the office of Professor Sycamore Kodama. Bizarre. And he was conducting research surrounded by Ainu ancestral remains like this. And the left picture is the repository house where more than 1,000 Ainu ancestral remains congregated. The first repatriation occurred only after the litigation. And this is the Native American National Museum. And this is a picture of a National African American Museum opened recently. Synopsis number 4. Regarding the environmental issues that are seriously prevalent among indigenous peoples across the world, the Ainu people also face the similar challenges. For example, the famous Nibutani Dam that submerged their sacred sites were built in 1990s. And Ainu people themselves, due to their poverty, worked for its construction as day laborers. The similar dam, named the Biratori Dam, is now being constructed. The industrial waste site was constructed in Monbetsu upon a sacred mountain without free, prior, informed consent of Ainu people. And it contaminates Toyooka River and blocks the upstream of salmon there. Thus, the UN expert mechanism should issue the warning towards Japanese government to implement UNDRIP and to stop the recent ludicrous legislative movement set by government officials and hired Hokkaido University professors across the heads of almost all Ainu people. This is a serious infringement of the right of self-determination of UNDRIP, Article 3. Without reparation approach based on their indigenous rights, the Ainu people still cannot live with racial dignity. Many Ainu people still don't want to identify themselves as Ainu. So this is a picture of Nibutani Dam. The fish ladder there is measurable. And this is construction Viratori Dam and the industrial waste site. And this is the last. The recent Ainu statute proclaims non-discrimination of Ainu people, but now seriously to remove discrimination, Japan should take reparations approach advocated by UNDRIP. Otherwise, what is called reverse discrimination discourse is prevalent among many people, including Director Tsunemoto of the Hokkaido University Ainu Indigenous Research Center. Every country has challenges, but some achievement with regard to indigenous people legal policy. For example, the Professor Charles Wilkinson's blood struggles shows us the nice overview of the history of the American Indian, Native people. And Australian, in Australia, Kevin Rudd made sincere apology about lost generation and so on. But Japan is the worst country among developed nations without any regional implementation system of international human rights on indigenous people, for indigenous people in East Asia or Southeast Asia. So Ainu people sincerely request the immediate UN immediate action. That's where Ms. Ryoko Tahara is coming to us by driving all the time. Thank you.
Professor Yoshida, it was a very interesting presentation for us as MRIP members in particular, because we have this new mandate and Erika will elaborate more on it. So there probably could be developments on how we can proceed with this case. And I recently visited also Sakhalin Island, which is a Russian island, and it used to be also an Ainu territory historically, but there are a few Ainus right now. And it's very interesting that, like a couple of days after this recognition act by Japan, the Russian president also said that we should recognize Ainu community and include it in the list of the Russian small number of indigenous people. So it can have also a geopolitical dimension, I think, this kind of simultaneous recognition by the two countries. But of course, it should be developed somehow in compliance with the declaration. And I agree with Professor Yoshida on this. So I would like to give the floor to the next speaker, Tracy. Please, grab the floor.
Tuatahi ki ngā whenua e takoto nei ki te whare etu nei, tēnā kōrua. Ki ngā tangata whenua o tēnei whenua, ara Ngāti Ut, Ngāti Cheyenne, rātou ko Ngāti Arapaho, he mihi nui ki a koutou katoa. Ki a koutou katoa, ko hui hui mai nei I tēnei rā. Tēnā koutou, kia ora mai tātou katoa. My name is Tracy Whare, I'm from Aotearoa, New Zealand. I am Māori and my tribal nations are Raukawa and Te Whānau Apanui. Firstly, I'd just like to thank the organisers for the invitation to attend this conference and giving me an opportunity to speak. But as our moderator has acknowledged, there's been a tragedy back home. Yesterday, a white supremacist went into 2 mosques with semi-automatic guns and started shooting, and as a result of that, 49 people have lost their lives. So personally, I'm very saddened and angry about what has happened, but I just wanted to acknowledge that that's happening at home, and just really offer my love to those whose lives have been lost and to their families, and to my country as a whole. So I'd like to share with you the experience of what is happening in my country in relation to the implementation of the Declaration on the Rights of Indigenous Peoples. And before I do that, I just want to give you a little bit of information about the political and legal landscape within which we operate. So New Zealand was colonised by the English and has fully adopted a Westminster style of government. So we have a unicameral parliament which has the ultimate authority to create law, only has one house. The executive branch of government is governed by cabinet, which is a smaller group of MPs who set policy, direction and determine such matters. And we have a judiciary that is appointed by the government, and it's supposed to be as neutral as possible, so it's not an elective process. The head of the state is the Queen of England, and she is represented at the national level by the Governor-General. New Zealand has no one written constitution. So its constitution comes from a number of sources. We have a Constitution Act, we have different ordinances and unwritten conventions as to how power is used and governed within the New Zealand context. The Treaty of Waitangi, or Te Tiriti o Waitangi, which is the Māori name for the treaty, also makes up that kind of bundle or parcel of what we understand our constitutional arrangement to be. It's often referred to by government as the founding document of New Zealand, and that was signed in 1840 between rangatira, which are chiefs, on behalf of their communities, and officials from the English government. The legal protection that's given to the treaty is sometimes not well understood, and the position in New Zealand, or the orthodox position, is that unless the treaty is included within national legislation, it has no standing, it is unenforceable. So it is not possible for Māori to simply go through the court system and point directly to terms of the treaty and say how they've been breached and how they need to be resolved, unless there is a specific mention of the treaty within aspects of legislation. New Zealand's population is around 5 million, and those who identify as Māori are about 15% of the population. I always like to make that comment because I think it makes us very visible within the general populace, which I think we have used to our advantage, I'll say that. So returning to the declaration, New Zealand, along with the US, rejected the adoption of the declaration when it was before the General Assembly in 2007. It has since changed its position and endorsed the declaration in 2010. However, the discussion or the understanding or the interpretation that the government gave at that time was that the declaration was aspirational in nature only. So we heard from Dean and I this morning about this whole concept of what is the status of the declaration. So New Zealand is very much, or has been very much, in that camp of retaining a much more conservative approach to the declaration. And clearly we were very keen to see what we could do with this document in the national level, but pretty much it was business as usual. Things just kind of plodded on. The government was happy with the arrangements that were in place for things like addressing historical land issues, and said that within our national context we were already implementing the declaration. Of course, as Māori, we beg to differ on that one. So in 2015, a group of Māori gathered to discuss how we could apply greater pressure to the New Zealand government and push for greater implementation of the declaration. And as a result of that, a working group was established, and that was called the iwi Monitoring Mechanism. It's an independent working group, and it comprises of representatives from tribal nations, as well as technical experts. And we also have co-opted some other people who have very specific thematic expertise, like people who work in the areas of Indigenous peoples with disabilities. Now, that working group reports to another body called the National Iwi Chairs Forum, and that's a collective of the tribal nations chairpersons, and it meets regularly to discuss and act collectively on issues ranging from constitutional transformation, resource protection, and recovery and economic development. The National Iwi Chairs Forum also addresses government policy and practice as it impacts Māori and engages in regular dialogue with government representatives on priorities, issues and projects. So, and I should say I'm part of the iwi monitoring mechanism as well as one of the technical advisors. So one of the first things we did was we drafted our own terms of reference, and we decided we were going to have quite a strong international focus. And so we decided that every year we would draft a report collectively, and we would submit that to the expert mechanism on the rights of Indigenous peoples. So to date, we have submitted 4 annual reports to the expert mechanism. Now, those reports canvass the priority areas that we have identified, and they provide up-to-date information on the status of Māori rights. Those reports have been influential in holding the government to account. One, because they have a great level of legitimacy in how they were created. We go out to communities, we engage in community dialogue and discussion, we ask them for their input, we bring that back together, and then we draft a document together and submit it on that basis. So it has good collaboration in its creation. But also because the body that submits it to the expert mechanism has a lot of legitimacy itself and is recognised by government, because it is drawn from many of these tribal entities that the government now has relationships with as a result of this thing called the treaty settlement process, which is a process the government created to negotiate redress in relation to historical land claims. So recently the MRIP mandate has been amended, and it now has a much stronger mandate. And one of the things that it can do is give advice about the implementation of the declaration at the national level. So we waited a year to see how that mandate was implemented and how the experts understood and were interpreting that mandate. We were very happy with what they were doing, and so last year we invited them to come to New Zealand and to help us. Because one of the things we had been constantly saying in our reports is we would like to sit with government and draft a national plan of action. So, good news is after a lot of toing and froing, the MRIP have agreed to visit New Zealand, and that is happening from the 8th to the 13th of April. And they have 2 clear mandates or terms of reference. The first is they're going to provide advice to support the drafting of a strategy, action plan or other measure, including specific measures and objectives to implement the declaration in New Zealand, with respect to Articles 3, 4 and 5 relating to self-determination in the context of substantive reforms and structures, such as constitutional rights, land rights, treaties, agreements and other constructive arrangements. And secondly, to provide advice on an appropriate engagement strategy associated with the strategy, action plan or other measure, with a particular focus on identifying how Māori will partner in the process of planning, considering, developing and implementing the strategy, action plan or other measure. So we're really cautiously optimistic about what we can achieve with this country visit and those terms of reference that have been set out. We think that they've decided to identify and tackle some of the really meaty parts of the declaration. And as I outlined at the beginning, our constitutional arrangement doesn't provide much legal protection for Māori rights, so the fact that they're prepared to address the constitutional reforms is very exciting for us. So, in finishing, just some reflections on how this has worked. And I think some of the things that we've done echo what Mr. John Echohawk proposed this morning. So we needed some infrastructure. The Human Rights Commission has partnered with us. They provide us with a technical secretariat. The people that are part of the iwi monitoring mechanism act in their personal or their volunteer capacity, I should say. We have a very excellent woman chair of our body who has strong leadership and works well within the Māori way of working, but also addressing government. And I think our decision to focus on international fora and use those platforms, particularly the MRIP, has, we think, has been a really refreshing, I should say, and positive way that we have sought to seek implementation. So, like Christine said, watch the space. I'm not sure what's going to happen with the country visit, but we're very optimistic that it will produce some good results. Kia ora.
Thank you, Tracy. Expert Mechanism is also very much looking forward to this mission. This is our third mission, and colleagues who lead on this mission, so they're working hard right now to get prepared. So I would like to give the floor to our last but not least speaker, Erika Yamada, please.
Thank you very much. I will also start apologizing for my voice and perhaps my English. I've been working in Spanish for the last week. But I always feel very privileged to be at this kind of meetings and working with Indigenous people, not being an Indigenous person myself. But I feel particularly privileged to be here today in the presence of some of my dearest living inspirations, whom I first met from articles and books or cases, and that developed to real experiences and deep experiences working in the field of human rights and Indigenous peoples, such as Professor Williams. I did my doctorate degree at the Indigenous People Law and Policy program at the University of Arizona. Dina Naya, Christina Koch. You have shaped my life in so many ways that I couldn't explain here. I would also like to thank Kristen Carpenter and Alexei, my colleagues from the Expert Mechanism, for also trusting me to be the chair of the mechanism for this year. It's almost to end because our year starts in May to July. MRIP, the Expert Mechanism on the Rights of Indigenous People, is a subsidiary body of the Human Rights Council, established in 2007, and today it's composed by 7 independent members. We serve on volunteer base and on our personal capacity, bringing experiences from our regions, and I always like to stress that we do not represent Indigenous people from our countries or regions, but that we bring experiences from the 7 social cultural regions to this work that we do for the UN Human Rights Council. In 2016, following the outcome recommendations of the first World Conference on Indigenous People Rights, the Human Rights Council amended the MRIP mandate to provide the Council with expertise and advice on Indigenous peoples, but also now assisting member states and Indigenous peoples, always upon request, to facilitate dialogue and to further implement the rights set in the declaration. We are not a monitoring body, such as treaty bodies or the special rapporteurs, and our role is quite unique within the UN, which is to actually assist states to implement those several recommendations they keep receiving every year from many different treaty bodies and even the UPR process as well, related to Indigenous people's rights. So now our new mandate includes offering this technical assistance and dialogue facilitation through country engagements, and to move on with national or subnational or local process of implementation of the declaration, as well as to implement recommendations from treaty bodies and the UPR and the special rapporteurs. For this year, 2019, we are working on a request from the Maori people, as Tracy just said here, so it's gonna save me some minutes. And also we are working on requests from the IITC, International Indian Treaty Council, to recover the Masakova from a Swedish state museum. So that is another case that is an ongoing dialogue to which Indigenous people found it could be strategic to involve MRIP as an international observer and advisor in that process of dialogue that has already started. Because as we always say, we do not bring solutions from MRIP, we much more bring experiences from other contexts and countries and strengthen the possibilities and the spaces for dialogue among states and Indigenous peoples. In addition to that, MRIP undertakes regular thematic studies on specific rights enshrining the Declaration. So last year, we presented our famous now study on FPIC, Free, Prior and Informed Consent. And for this year, we will discuss during our sessions our study on migration, border and displacement. And we hope that will also influence the implementation of the UN Global Compact on migration for the countries that are signed for that. And it's interesting to say that when we were discussing migration, borders and displacement, we wanted to focus on those situations of migration and border issues that are not explicitly stated in the declaration, because in the UN declaration we have article specifically talking about Indigenous people that live in transborder, they're not bound by border states. But we also wanted to talk about migrations from very distant places to and from international borders that are not necessarily transborder people. We have also started to work more closely to treaty bodies. So to each of our sessions, we invite treaty body representatives to learn more about UNDRIP, the declaration, and about Indigenous people situations all over the world. And this year, we are very excited to have a different panel where we're calling it Indigenous Women in Power, where we're inviting Indigenous women that have been elected in all of the 7 regions to national positions of parliament, and to share their experiences on how they got to those positions and what are the challenges that they see, but also to inform how the UN declaration can support their work as well. And you can also be part of our sessions. This year it's going to take place from the 15th to the 19th of July. It's always in Geneva. And even if you can't travel, you can follow and be part of it by webcast. During the last year, the expert mechanism engaged with the Mexico City government doing this technical assistance to advance the implementation of the Mexico City, Constitution. Okay, I only have 5 minutes and I wanted to bring some messages from Brazil as well, so I'll try to be short. So we are still negotiating with Mexico City on how to make public our advice for secondary laws to be adopted, because Mexico City had just adopted a new constitution which makes reference explicit to the UN declaration. We also had a request from the Sami Parliament, where we contributed in with a technical note on the review of specific articles that deals with representation of Sami in the elections for Sami Parliament. So now I would like to bring some reflections from my country, Brazil. Let's see how I do this. Okay. And I will ask for, how should I do this to look better? This is not my pictures, not my presentations, but it comes from Indigenous movement from Brazil. And I always like to take the opportunity when we are in international forum to bring their words as well. So I'll just be skipping the presentations, which is a lot in here too. Brazil is home to over 300 different indigenous people that speak 280 different languages. And the government also recognizes at least 26 groups living in volunteer isolation. And we have advanced a lot for the past 30 years, but we are living times of significant regressions right now. In Brazil, indigenous people have territories in all of the 26 federative states, but are struggling and resisting. We have the cases of the Guarani Kaiowá waiting in very precarious and vulnerable situation. Maybe I'll ask for Agile to help me with this. The Guarani Kaiowá, which are indigenous people still waiting to have their lands recognized, but we also have cases such as the Yanomami people who had their land cases recognized even through international disputes in the early 90s, but still suffer from various kinds of illegal activities, intruders, mining activities, and so on. So basically what we have today is that our indigenous leaders seem to continue to bring the same claims as of 20 or 30 years ago. And our newly elected president expressed his will during the campaign to actually go back 50 years with regard to indigenous people's rights. And he does not hide his blind admiration to Trump's administration, so I really think whatever you do here will be significant for indigenous peoples in Brazil as well. So what we have now with this threat of going back 50 years in time is to have an assimilationist discourse back in place in policies, as well as disregard for our constitutional and legislations that formally recognize indigenous people's right to lands, cultures, and social forms of organizations. Likewise here, under the assimilationist views and policies that formally existed 50 years ago, or perhaps saying since colonial times, it was accepted and naturalized the idea that indigenous people would disappear. Countless cases of mass killings of indigenous people, sterilization of indigenous women, removal of indigenous children, torture, slavery were long ignored by the state authorities when not supported by it. A National Truth Commission started to bring up those cases and found that at least 8,000 indigenous people were killed under the dictatorship regime, but so far there has been no meaningful process of reparation and reconciliations for those groups. Although today it's not always explicit, the desire for the physical extinction of indigenous people, assimilation is now being promoted mainly through the denial of collective rights by states, and sometimes framed as an exchange for individual rights. I had so much more to say, and my time is... Okay, thank you. So maybe, what I should say is that we are living this time of regressions, and that many of the rights set in the Constitution and legislation, which are in line with the Declaration, are under threat to be revised or extinguished. And indigenous people are resistant and are making a great use of the UN Declaration on the Rights of Indigenous Peoples. So despite of language barriers, indigenous peoples from Brazil are finding these international forums and claims sometimes as the only venue to have their voices heard. That has led to an increasing participation of Indigenous people in the Inter-American system, at the Human Rights Council sessions, at the Permanent Forum, and also at the expert mechanism. Precisely due to the state's disregard to Indigenous people's rights, there is much more awareness of the declaration and of the role of the special rapporteurs among the major organizations. But still, it is also true that for the most part, grassroots level organizations do not know the declaration, and even the ILO, which is a binding instrument in Brazil. Although they do know the content of the declaration, and it empowers them so much when they know that what they know about rights is written in instruments that can be used and have legal effects for them. So this is something to be highly considered in strategies for implementing the declaration, that even if for major organizations it's clear that the declaration is a long existing instrument, for many of Indigenous people it's not known at all. I should also say that in Brazil we had the visit of 2 special rapporteurs, and that has raised a lot of awareness of the declaration and has made the most emblematic cases of violations gain visibility. It also made clear the recognition of a persistent institutional racism in Brazil against Indigenous people, but still no concrete measure has been taken from the part of the government to implement those recommendations. Needless to say, a national action plan to implement the declaration. On the other hand, the interaction with the Special Rapporteur brought the main Indigenous organizations and many of the leaders closer to the UN system as a whole, and in 2017 they organized themselves to do a strong advocacy around the UPR processes. So from 9 recommendations of the previous cycle, they managed to get 32 specific recommendations of the UPR mentioning Indigenous people's rights. And those recommendations are around the 3 main demands, which is land demarcation and to stop violence against Indigenous people and to guarantee legal protection of human rights for Indigenous people. But how to move from implementation? Following the increasing understanding and participation of the different UN mechanisms and instruments, the major coalition and organizations of the Amazon have, for example, are supporting an Indigenous woman for the first time from Brazil to compete for a sitting at the UN Permanent Forum this year. They have also presented a request for technical assistance to the expert mechanism to assist the dialogue between Indigenous people and the government in the establishment of indicators to define when a recommendation of the UPR is being implemented or not. So that could be done in preparation of midterm report or also for the cycle ending of the UPR. And we are still waiting to see what will be the state's response, because even though at the national level there is this complete disregard and a lot of hate speech against Indigenous people, at the international level we see beautiful speeches from the state authorities with regard to human rights and even to Indigenous people's human rights, which we know it doesn't find coincidence in the national level. So, given the struggle of Indigenous people in Brazil and their plea for alliances and international solidarity, I encourage you to manifest support whenever possible and to not forget that the advances that you make here triggers advances in other parts of the world as well. I also think it's a spiritual battle that is in place. With all these assimilationist initiatives, we also have a growing attempt of opening Indigenous territories for mining industries, but also for strengthening the presence of missionaries in Indigenous land. And many of those initiatives have headquarters in the United States, such as the New Tribes, Youth with the Missions. They're taking over many of Indigenous territories in Brazil. So it is a spiritual battle. And it's certainly one field where Indigenous people connect. The spiritual field is where you connect even though we're not physically present to each other, and where language doesn't matter. So thank you.
Thank you, Erika. So you forgive me, I gave a little bit more minutes to Erika because he was challenged to talk about MRIP and the national situation, so it's quite a lot to talk about. And I would like to also say that, and join Erika with saying that our new mandate with the country engagement component of the expert mechanism is very important, and you see how some indigenous peoples already use it, so the practice is being developed. So I mean, we would like to ask also indigenous peoples here in the United States and North America to look at this mandate and provide us with requests, and hopefully there will be good practices about this country engagement. So unfortunately, we do not have time for discussion, and I would like to thank the panelists for the excellent presentations, and we could use the coffee break for personal discussion. So we have now coffee break for 15 minutes, and then we reconvene. 10 minutes even, 10 minutes. Thank you.